So I want to do a short video on the appellate opinion that just comes out of Florida 2nd DCA yesterday, Spencer versus Ditech. It's an opinion on April 4th, 2018. It appeals a final judgment of foreclosure that was entered in a foreclosure case in Hillsborough County, and it describes a situation that's all too common in the context of foreclosure cases, and that is a bank comes to court with insufficient evidence, and the court gives the bank a pass, and rather than holding them to, I was going to say strict rules of evidence, but in fact sort of basic or fundamental rules of evidence, the court instead just grants them a foreclosure. Because why? Well, this is foreclosure, and we don't need to hold banks accountable. It seems to be the prevailing wisdom in foreclosure courtrooms all across the state. It's been going on for many years now. Now, of course, the pendulum swings back and forth, it seems, for many months into the years as we got past the big bulk of foreclosure cases. It certainly feels like the pendulum has swung dramatically in favor of banks, such that bank lawyers come into court not prepared. They've been educated over many months and years that they don't need to be particularly prepared because the courts are going to work with them, give them a pass, and help them get foreclosures when they're not entitled to it. Well, comes out of the appellate court a recognition of that. And what this appellate opinion describes is the all too common occurrence among appellate judges and appellate courts to, even when a foreclosure defendant takes a case up on appeal and proves to the court that the trial court was improper in granting judgment, particularly because their evidence was insufficient, the appellate court gives the bank a pass. In a situation that seems kind of unique in foreclosure cases, that even though the appellate court admits, hey, trial judge, you were wrong, hey, defense attorney, you were correct in bringing this appeal, rather than do what is common in civil cases, and that is dismiss the case with instructions on remand to dismiss the case, what the appellate court says is, you know what, just send it back down to the trial court, let them fix their problem, and go ahead and grant them a judgment anyway. It's something that on the defense side of the equation, we've watched for many months, even years now. We've been warning about, and now finally we've got an appellate opinion that describes some of the concerns that we've been expressing. But let's talk about what's happening, sort of the big picture. The big picture is that the trial courts, of course, in the rush to just grant judgments for banks, have been granting judgments for banks in cases which are utterly impermissible and inconceivable in any other circuit litigation. We would hope that if there's some kind of balance and fairness and integrity and paying attention to the rules, we wouldn't be granting judgments to parties coming to court not prepared or not having proper evidence. But all too often in foreclosure cases, the banks are given, as one judge told me, a mulligan. Literally, we're in trial, the bank loses, they don't have what they need, and the judge looks at me and he says, you know, I'm just going to give them a mulligan and let them do it over again. I would like to say I'm shocked by those kind of comments, but I'm not. It happens all too often. But what happens here finally is we have a judge in the 2nd DCA, Judge Solario, who writes this concurrence on an opinion that dismisses this case. And what he recognizes is, you know, we've got a problem here where in some of our prior opinions and opinions across the state, we are returning the case back down to the trial court, not with an instruction to dismiss it, but with an instruction to give the bank a second bite at the apple. He quotes here that the default position is that there is no new trial when a party fails to prove its case, and we reverse a judgment in its favor on appeal. My own inclination is that the interests served by the rule demand that a party present compelling equitable circumstance to justify a departure from that position. What he's saying is, in most cases, virtually all cases, and in fact in a footnote he says you can find no case where that doesn't occur. But again, the default position is that if you don't make your case at trial, it comes up to the appellate court, we then reverse it with instructions to dismiss it. He quotes and goes further and says, something different, however, seems to be happening in foreclosure cases. We have been determining whether to grant a new trial according to considerations that either appear alien to those that underlie the general rule or that are not clearly tied to a legal principle we can apply across cases. And again, listen to what that says there in plain language. He says, wait a minute, the general rule in appellate procedure is that if a party has failed to fulfill their burden at trial court, we reverse the case with instructions to dismiss the case in favor of the defendant. But what he's saying here is, but that's not what happening in foreclosure. What's happening in foreclosure is we are dismissing cases and giving the bank another bite at the apple. It really is a disturbing set of circumstances. I'm glad to see an appellate court is finally recognizing it. And what he says, again, back here on page 12, the last page, at least on the basis of what our opinions say, quote, this is a foreclosure rule, maybe the only answer we are able to give for not extending it. But the answer is not going to be a credible or persuasive one. What he's saying here is a recognition that what we've been talking about for many years now, and that is the courts are carving out a separate set of rules for foreclosure cases because, after all, banks are special, and we should be generating a special set of rules for them that give them a pass. This opinion is a recognition that that's not appropriate. Now, I would like to see some sort of widespread recognition of this across the state so that we don't have these circumstances where PCAs, that's per curiam affirmed, are being granted widely across the state, hundreds, maybe even thousands of times in foreclosure cases, where the appropriate remedy should be a dismissal in favor of the homeowner, but instead, because banks are special, they're just getting a pass and they're upholding just grossly abhorrent opinions and trial court rulings that shouldn't stand. This opinion here in this DITEC case will stand, in my mind, as one of the ones similar to in the dissent in Bouvet, where the appellate court recognized that what they were doing was aberrant to long-standing fundamentals of contract law, particularly with respect to statute of limitations. So essentially what the court's done is rewritten the rule on statute of limitations, made it special for the banks and let them get away with it. Hopefully an opinion like this Spencer versus DITEC will start to have appellate courts wake up and recognize what we see is that, judges and practitioners in all other areas of law are saying to us that some of these very bad and aberrant opinions that occur in foreclosure cases are now popping up in the context of other civil litigation cases, and they're setting very bad law, setting very, very bad precedent where corporations, institutions are using these very bad decisions in foreclosure to their ends in these other cases. It sets up very bad law.